Hi, my name is Chantal, and I'm a partner at the law firm of Lister Beaupré. Now, today, what I'd like to discuss with you is how invaluable employment contracts are to the employment relationship. Now, an employment contract is usually known as an amalgamation of written, oral, and legislative terms. The goal of the employment contract is to ensure that the parties, both the employee and the employer, are aware of the terms and conditions of the employment relationship. Now, a contract of employment that is in writing will usually contain information with respect to the position held by the employee, the salary, any commission structure, whether the employee is owed or entitled to any bonus. The employment contract will usually as well address things like probation periods and other employer obligations to third parties. Now, our recommendation is for employers to ensure that they present contracts of employment in writing to potential employees prior to the commencement of their work. So typically, the employer would send a copy of the written offer, the written contract of employment, to the employee and have that individual sign the contract prior to commencement of work. Written contracts of employment are also extremely invaluable because they assist the employer in establishing limitations and restrictions to the employment relationship, either during the term of the employment relationship or at the end of the employment relationship. For example, an employer can request that the employee sign a non-solicitation clause that will prohibit the employee from soliciting clients of the employer after they are either terminated or resign from their employment. There's also the possibility of adding a non-competition clause to an employment agreement, to a written contract of offer. Now, a non-competition clause would prohibit an employee from working with a direct competitor of the employer after termination or after the employee resigns. Also, a written contract of employment could put in place some provisions with respect to protecting the employer's confidential information upon termination. And what we mean by confidential information is things like marketing strategies, customer information, selling strategies or techniques that are used by the employer and that are only used by that employer. Now, most importantly, a written contract of employment can assist the employer in limiting the amount of notice that is owed to an employee upon termination. The Employment Standards Act provides for the set amount of notice and or severance that is owed to an employee upon a termination without cause. Now, in addition to that, if the employee does not have a valid and enforceable contract of employment, an employee can claim what we call common law notice. Common law notice is over and above what the Employment Standards Act offers to all employees. Common law notice is usually based on the position that the employee held, their years of service, their age, only to name a few factors. Common law notice can also be quite lengthy. So a properly written contract of employment can assist the employer in limiting how much notice, including common law notice, would be provided to an employee upon termination. In our view, this is advisable because it provides certainty both to the employee and to the employer upon termination. Now, we invite you to contact us should you require any assistance in preparing or presenting written contracts of employment to your employees. Or if you are an employee, it would be our pleasure to assist with a review of any potential employment contract that may have been presented to you.